Hey everybody, this one is about all courts are Roman cult courts. And so let's get going. There's basically three kinds of jurisdictions. There's admiralty, which is the Roman cult. There's equity, which is the Roman cult. And there's common law, which is the law of the land and law of the people. But you don't see too much of that because the Roman cult has made sure that that's not going to be around. Anyways, this is Constitution for the United States of America, Article 1, Section 8, Clause 17, to exercise exclusive legislation in all areas whatsoever over such district, not exceeding 10 miles square, as may by cession of the particular states and the acceptance of Congress become the seat of government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state in which the same shall be for the erection of forts, magazines, arsenals, dockyards, and other needful buildings. So this is talking about D.C. and federal enclaves. And this is the D.C. Code, which was passed in 1901. Which is located at 31 Stat 1189. This is an act to establish a code of law for the District of Columbia. And it says in Chapter 56, Section 1617, and that's at 31 Stat 1432, it says, the legal estate to be in the cestacea use. And in the 1800s, a trust was called a use, which is short for usufruct, okay, under Roman law. This is Tomlin's Law Dictionary, 1835 edition, volume 2, under the definition of mort main. And this is very revealing, okay? This just reveals all sorts of stuff. It says, yet still it was found difficult to set bounds to ecclesiastical ingenuity. For when they were driven out of all their former holds, they devised a new method of conveyance, by which the lands were granted not to themselves directly, but to nominal feoffees, to the use of the religious houses, thus distinguishing between the possession and the use, and receiving the actual profits, while the season of the lands remains in the nominal feoffee, who was held by the courts of equity, then under the direction of the clergy, to be bound in conscience to account to his cestacea use for the rents and emoluments of the state, of the estate. It is to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. This says so many things. First of all, it says that a cestacea trust was set up by the Roman cult. That's what it says. Think about it. That's exactly what it says. And it talks about property taxes, okay, or any kind of taxes, really. It was held by the courts of equity, then under the direction of the clergy, okay, so the courts of equity even today are under the clergy, okay? All these bail priests, and that's the purpose of this whole video, is to show that these people are nothing but a bunch of bail priests. The courts of equity, then under the direction of the clergy, to be bound in conscience to account to a cestacea use for the rents and emoluments of the estate, okay? That's the taxes. And then it says it is to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. In 1835, the cestacea used was the foundation of modern conveyancing. Well, it's still today. It's exactly what's going on today. That's why they spell the name in all block capital letters. It's a cestacea use that's set up by the Roman cult, and they want their extortion. In 1835, the cestacea trust was the foundation of modern conveyancing. The cestacea trust is a creation of the Roman cult. In 1835, the courts of equity were run by the Roman cult. They're still run by the Roman cult today. The Roman cult wanted to make sure that they get their rent and emoluments, which is extortion, for their owned and operated Sestake Trust. When Congress passed an act, think about this. When Congress passes an act to establish a code of law for the District of Columbia, and it says the legal estate to be of the Sestake use, think about it. They're essentially saying that the Roman cult owns the United States. That's what they're saying. Why do you think Congress has those fascists right on their podium? Every taxpayer is a Sestake Trust having sufficient interest in preventing the abuse of the trust to be recognized in the field of this court's prerogative jurisdiction. Okay, this is in Boland's Northwest Court case, probably Washington or Oregon or something like that. This is congressional record. A citizen of the United States is a civilly dead entity